criterion is not really the formal marriage contract, nor even particularly the gender of the parties in a couple, but particularly the presence of children. So once children are in the picture, whether they're born out of formal wedlock or not, the concept of a family seems to be integral at that stage. So that's interesting in terms of just having something that comes out of the community and the perceptions of what a family is, rather than something that is defined legally. We did see in the course of that research that there's quite a bit of cultural variation in terms of the reasons for marriage, how marriage plays a role in different communities, which of course then has implications for the consequences of divorce or dissolution of a marriage. And so some of the history of what led to marriage contracts, if you look at it, really, is often, quite economically driven in terms of interest between different families, or might be driven by religious affiliation, or other aspects of culture. And so it's interesting to reflect on notions of marriage, and in different kinds of cultures, the reasons that people choose or choose not to get married are very driven by the kind of context in which they live. So if you look at a lot of individual-centric cultures, primarily Western cultures, you'll see that the individual interests in personal satisfaction and well-being are paramount and dominate over other kinds of cultural factors, whereas in a lot more collective societies, the notion of the importance of a marriage within that broader context tends to take precedence over the individual interests. So people who are from one culture or the other and living in a different kind of cultural context may experience quite a bit of personal conflict over which way to make those decisions. And so I've had quite a few students sometimes in my class in Australia, living amongst Australian values, whose families have arranged marriages for them, who come in distress and said they don't know what to do, they don't want to offend their families, they feel that they ought to have the right to choose because of what they've been acculturated into in a different context, but this has precipitated a tremendous family conflict if that was their thinking, and those could be quite difficult issues for people to resolve. In Australia, we have had ongoing attempts to legalize same-sex partnerships and unions with legislation on marriage, and I'll delve into that in a little more depth in the next slide. What we do find is that many countries around the world, and especially in the last decade or so, have approved marriage between same-sex partners. But generally, the law is pretty slow to catch up with social norms and values, and so there are problems, societally when the law doesn't move at the same pace as social change. And so socially, we seem to accept far more broad notions of gender identity than is necessarily reflected in a lot of legislation, or cases that have evolved, and those principles become challenged. And so, for example, I've even found when sending out research surveys, when you come to the typical question on what is your gender, the socially appropriate thing these days is to add an other box, so not just restrict people to male and female options. And when I tried to do that recently on an Australian government-sponsored survey, I got back, comments saying, "What is this? Do we need this? What are you doing?" Because it was very difficult for them to conceptualize of the fact that socially now, that's really not adequate And people who are forced to make those choices often feel very confined by them or drawing their own boxes, indicating others. So the social responses are going to have to be motivators and drivers of some of the legal change. Right, so when we look at what there's some questions and comments. Yes, please do just put up your hands, don't wait for me to pause.
I was just sort of thinking that it might be, before we went further, just a little bit of a framing of how it happens here. One of the things which is like in context of the whole business of whether how you define a family or the whole fact of marriage, whilst we do have a secular law which kinds of takes into account people marrying, interreligiously. Otherwise, the way in which our personal law operates is like it's defined coming from the religion. So, like if you are a Hindu, you have a Hindu Marriage Act, and you might, like if you are belonging to one of the other religions, each religion has either a statutory or a customary kind of recognition. That's one of the, I would say, as a counter thing. And also the notion of family for us is like both the nuclear family and the extended family. And the extended family as such being recognized as a legal entity. So, which kinds of has some sort of a role when you come to the area of adoption and custody and stuff. And especially when we are talking in terms of inter-country adoptions and who are the kind of children who can be sent out and stuff. But in the kind of formalized and not so formal relationships of marriage, one of the things which has been a major issue for us is that where do you put in the second wife if you in fact have, and that's because if you could take in the gender question, the fact that the second wife very often may have just been promised that all will be well and I'm going to do this, that and the other, and then what are her entitlements under the law? That's an entire large body of. One is of course people who haven't got married, the point which you have put in the lat which comes in later, that I would sort of share there. But the fact of that you are supposedly married, but the law doesn't recognize. So what are your entitlements and not is a whole very, very problematic area of family law for us here. And whilst you want to be promoting monogamy, so you say that there is no legal recognition for the second marriage, but what do you do to the person who, one, believes herself to be married, and two, has kind of been made very majorly economically vulnerable, because we don't have a system of matrimonial property, we basically operate under maintenance laws. So then it becomes a disentitlement on that ground. There are cases where courts have recognized second marriages to the extent of providing some sort of entitlement to the second wife for maintenance. But it's not a consistent trend. And the same-sex union and as well as the trans issue has kind of got, we have a provision under the penal law by which you actually sort of had criminalizing of what you termed as sexual interaction, which they called, because it's a British law which came in against the order of nature. So we had a High Court of the country which struck it down as unconstitutional, and then the Supreme Court of the country restored it back, saying that no, this is not our business. It is, if it has to change, let the legislature do it and stuff. In relation to trans persons, we've had a relatively more progressive articulation coming in from our Supreme Court and saying that yes, they have entitlements which are analogous to what other people are to get. And more recently, we've had a privacy judgment wherein it looks like that the whole question of you could say gay rights may get addressed differently and within the rubric of privacy. I just thought that it would kind of give you also a context that we have a really, really messy family law and largely patriarchal with certain kinds of efforts at bringing in the gender justice issue. So as a counter sort of thing, very worthwhile for us to keep that in mind. And especially just yesterday, and with that I will stop. Just yesterday, we had a case where the Supreme Court of the country has held that if, like you have this general tradition where you get married, you go and live with your husband's family. It's not just with the husband, but with the entire family. And you have this case of where after the marriage, the husband had to go out of the country, and the rest of the family was not talking to this young bride for days together. And she kind of, as a result, felt so, I suppose, oppressed that she moved out and went back to her parents and sued the husband for wanting a divorce and ground of cruelty. And the apex court of the country is saying, just because nobody is talking to you, it's not cruelty. And it kind of signifies that the sort of role and expectations in which you are. And I also felt it's a kind of a psychology of the law that you have a certain expectation from the woman in the marriage. So on the other hand, if she was disrespectful to his parents, or she otherwise did not fulfill what was seen as marital obligations, you had any number of decisions terming this to be cruel conduct. But when the reciprocal obligation is talked about, here is somebody who's come into your household and nobody feels that they should even speak to her. And the judges of the Supreme Court believe there is nothing cruel about it.
Right. And of course there's some quite good psychological research on the concept of ostracism.
Yes.
And one of the indicators of ostracism is non-engaging in social conversation, that sort of exclusion or ignoring people, is a manifestation of it, and that has been shown to have deleterious psychological effects and impacts which would answer some of those issues about is this a form of cruelty or isn't it?
Yes, absolutely.
So very, very interesting. Right, and of course, part of the concern over gay rights has been some of the very disturbing cases where partners over many years have, when emergencies happen, one partner has gone into a fatal coma and the other partner, not being a recognized spouse, has been excluded from the hospital room, has been excluded from anything to do with wrapping up that person's affairs after their death, excluded from any joint financial contributions and inheritance. So, there are immense economic fallouts as well as psychological fallouts that seem to be attendant upon the recognition of those partnerships, irrespective of whether there's actual legal marriage or not. So in some Australian states, those rights are provided, notwithstanding the fact that legal marriage of same-sex partners hasn't been approved by legislation nationally. Those rights are all provided in some states, but not throughout the entire country. So that's an incentive for gay couples, at least to make sure that they're resident in states where those rights will be provided. And I think part of the progressive nature of some of these developments was spurred in Australia by the fact that one of our most esteemed High Court judges had a well-known, long-standing gay relationship, and so that has in many ways, I think, sort of opened the door by virtue of his authority and the respect for him as a judge throughout his career, paved the way for some of these changes.
Yeah, he's a very frequent visitor to India, so it's like we have, I think, with Judge Kirby quite a strong relationship. So the fact of how much the leadership role he's played, I think, is something that maybe we are much more in knowing of than other aspects of Australia.
And continuing that leadership, since his retirement from the bench. Very interesting. Okay, so if we look very closely at who these living apart but together group consists of, I think what was very surprising, I think this came out of an Australian Bureau of Statistics survey, about people's residences and whether they were considering themselves to be single or not. What they found is that it's quite a high proportion of the population, maybe have verged on 10% by now, and that they're being misclassified as single just because of their domicile or their residence as single, whereas in fact they're more like long-distance partners or partners when they can be together. And professional careers are driving more and more young couples to live in this way. Sometimes even in different countries, So, I've had PhD students who've gone on, married, and their husband could find a job in one country and they found a job in another, and they had to try to figure out ways to live in countries that were reasonably close so that they had a chance of commuting and meeting each other reasonably frequently without too many onerous costs. So those are some of the features that lead to this, but others might simply be personal preferences. But I think the important social psychological thing to realize is that we make a presumption that people are going to have a unitary domicile if they're married, and there are many other permutations of that are simply might not be the norm, but are increasingly common. And the law needs to take some of those issues into account. And I've left off the queue there, sorry. And LAT certainly might be regarded as families, or if they're not, under the de facto criteria. So sometimes when you have to deal with the legal status, financial issues, because Australia uniquely allows people the same rights as married couples if they meet a set of criteria for being de facto relationships, even if you don't meet those, even if you don't have a marriage license, you can, through this group of criteria, of which you only have to meet a minimum number to qualify, sometimes be regarded as a family, and then that might give you all of these expanded rights to maintenance, to property, and of course also to custody of children if that becomes an issue. I think that's certainly not true of the United States. I don't know how many other countries are as clear in acknowledging de facto partnerships, but it seems to work quite well. So I think I've become quite a supporter of that scheme of arrangements compared to legal marriage arrangements. And what you're finding today, and as you'll see, Australia has a pretty high divorce rate, as to many countries. Ours is somewhere around 40%. And so, young people these days who take that into account when they look at the statistics and look at the families to which they belong, become more reluctant to remarry because they don't want to end up being labeled as twice divorced or something later on in their life. They see that as a negative way, so they would prefer to avoid marriage formally so that they can avoid that sort of label that they see as perhaps associated with failure in their relationships. And it really is an issue as to why we might regard that as a failure.
But breakup of the relationship is not seen as a failure?
A couple that breaks up? Not in the same way. I think just because of notions of the normativeness of marriage and then divorce is seen as something that flies in the face of it. And so if you've gone through that process more than once, this is what young people are saying. They don't want to be faced with early on looking at themselves as labeled.
The reason I'm asking is that when you don't have, say, recognition of lived-in relationships, or the fact that you are living together right without being married, if there is no legal recognition, I can understand that people see this as an internal management affair, and hence whether it's a success or a failure is nobody else's business. But considering you do have recognition of relationships which go beyond a certain, at least in terms of continuance of period and stuff. So if it breaks up, how is that very dramatically different from a marital relationship? I mean, that's what I'm...
Sure, I don't think it's personally different. I think these are particularly from individuals who are looking at that label in light of what other countries attribute to multiple divorces. So some people favor serial marriages and others have different views about that. Is I guess what is some of the feedback with that sort of input. And it doesn't seem to have the same negative implications as breakups of other relationships without those legal appendages. So we're going to have a look at what's going on in Australia at the moment with legislation of same-sex marriage, because very hot news this week. And you need to know that for years now, Parliament has been tossing this idea around. It was virulently opposed by John Howard when he was the Prime Minister. There was an opposite view by Julia Gillard. Then, subsequent leaders from the Liberal Party have had different views about it. Tony Abbott thought it was a threat to religious freedom, and so would not support it in any way. And in, I think, about 2010, there was a survey, but not a very large-scale or formal one, that indicated there was about 38% support in the community. Recently, the Guardian newspaper did its own kind of poll. Again, I would, add the caveat, it's not a very substantial empirical piece of research, but they had such a wide range, you hardly know what to make of it. If they say the range is 32 to 57% of support, and I think that's based on different states. So the government has been trying to figure out how to go forward, because countries everywhere else are, solving the problem in Australia has been lagging behind. So what they did last year was they proposed that there be a direct vote by the entire country, and we have a mandatory voting system. So if you're on the electoral roll and you don't vote, you can get fined. And so we have a higher turnout than countries like the United States, where voting is not mandatory once you're over the age of 18. So they decided they wanted to do it by vote. I suspect that they thought that what would happen is it would fail on that basis. But even so, it was going to be a non-binding vote, just to provide more information to Parliament so that Parliament can make the ultimate decision. But they ran into some odd problems. The first one was that the Electoral Commission could not be ordered by the Commonwealth to spend the money that they estimated would be required to field the survey, to the entire country. We don't have the hugest population, but nonetheless, they came up with an estimate of about 122 million as the cost of doing this nationwide survey. And so things fell apart because that mode was constitutionally deficient because of a funding provision. So they went back and thought about it further, and then this year have proposed a postal survey that will instead be administered not by the Electoral Commission, but by the Australian Bureau of Statistics, which constitutionally, has the empowerment to spend money on surveys, although they don't usually do anything very nationwide. But they ran into another hitch, because in our electoral system, normally, you're listed in your precinct with your name and address, but there are some people who are silent voters, which means that they have made a special application which has been legally vetted, that they do not have to have their address disclosed and included on the electoral roll for various reasons, such as they might think that maybe members of their family will be subject to threat if their address is public. And so various people go through this process. And so the difficulty is that the ABS cannot mail anything out to people who are silent voters, so they would be excluded from the vote in this way. So now they've figured out a procedure where the silent voters will be approached only by the Australian Electoral Committee in a separate mailing that, where funding has been provided so that they can be included. So that there were other challenges to this process, saying that the Australian Bureau of Statistics is only authorised to gather, sort of bald, factual, objective information from people, and not their opinions on matters at all, such as same-sex marriage, which was regarded as just an opinion survey or an advisory kind of survey. And most of the groups, advocacy groups in particular, that mounted that challenge were supporters of same-sex, or people arguing, that if there were, for example, a same-sex family with children, that this was going to cause distress to their children, who might be regarded by others in the community as living in a situation that wasn't legally sanctioned. And so there have been a variety of debates about just getting this survey going. So that issue and all of the challenges went directly to our High Court. And the High Court did something quite unusual in this last week. Within 24 hours of getting that challenge, rendered a decision, which just happened a few days ago. On September the 7th, the High Court said, yes, the ABS can go ahead and do the survey because they have always asked people about their religious beliefs. And so beliefs about same-sex marriage fit into the same category, that was the argument made to them. We don't know yet whether that was actually the reasoning adopted by the High Court, because they made this decision in such a hurry that they haven't yet released their reasons. And so the survey is going to commence on September 12th. Results will be announced to the Australian public on November 15th. And somewhere fairly soon, maybe between those dates, the High Court will deliver its written opinion with the reasons that it has allowed this process to go forward now to try to resolve this sticky issue. So you can see there's been immense, political and community engagement in this issue that's going to be even broader. But at the end of the day, it's still going to be a non-binding advisory set of information for Parliament to consider. Our Prime Minister thinks that if there is, widespread support, and I'm presuming maybe over 50%, that the matter will go through legislatively in very short order. Precisely what will happen if that's not how the results turn out, we're still discussing and debating, don't know yet. Yes, your comment or question.
Other than the exceptions of
silent voters and the issue about opinions being garnered and not garnered. My question is would this survey impose, like the other one, the previous one, the plebiscite, compulsory voting else you're fined? Would this survey also have that kind of obligation on the general public? Otherwise the survey may be done as people may just not respond to it.
Right. I think that it's going to be mandatory, even though it's through the ABS. I think that sort of becomes a mechanism as to how it's fielded. But yes, I think that if I'm away, I'm going to be worried about how am I going to get my vote in so that I get fined. We're taking it seriously as voters because we know what's at stake electorally. I think it will be informative for a wide range of policy issues, irrespective of whether it's over 50%. I don't know if I can otherwise further address your question.
Compulsory voting would be by some statute. So if this is to be extended to this postal survey, wouldn't they need some kind of amendment to existing laws, etc. I'm sure that you are trying to get in your voters. I appreciate that bit, but other than that, my question is on whether
you mean, well, I mean, this is not law. This is just, you know, the community opinion intended to advise our legislators. So the legislators have to take action, and we're not quite sure yet. You know, they're saying what sort of action they will take, but we don't know what will happen depending on how the numbers are arrayed. So I can't say that it's going to be mandatory.
Do you have any kind of an opinion on the fact that governments are suddenly, governments are, instead of taking the cause themselves, are suddenly asking for these various kinds of polls happening? I mean, see, the Brexit option also had come because the then Prime Minister had thought that he was going to win it. And he felt it would further strengthen his case. And it just went the absolute opposite way. And as you were saying, that presumably one of the reasons for going to the people is that you believe that the people would defeat it, and hence they won't have to do anything. And it may go anyway. But I'm just wondering that what is this new trend somewhere of wanting to go for more plebiscites and, those sorts of let the people decide kind of issue, which is, I think it's a more recent sort of trend. And I'm also fascinated because at least some of the work that people have done around data crunching, they're saying the way in which data is starting to get collected and the manner in which people are getting targeted, you are able to give this very personalized kind of messaging to people, and hence can get the you kind of making those sorts of recording of people's choices and then messaging them accordingly to push them in certain directions. So that, along with this kind of thing where decisions which representatives of people should be taking, they are unwilling to take. I was just wondering if you had any thoughts on that topic.
I think that one of the really interesting political theories, but it's as much a social psychological theory on which I would draw to respond, is the growing support in the last several years around the world for the notion of what is called deliberative democracy. And the principle is that even if you have representation, through electoral processes of your representatives in a democratic system, that's not quite the same as actually engaging the community more directly to reflect their opinions and to deliberate about various public issues. And so there's been scholarship focused on various mechanisms that can take that idea of more in-depth engagement and discourse expansion and discussion to provide more frequent and functional vehicles for the community to bring feedback to their leaders about various social issues that may or may not be paramount in determining legislation at the moment, but certainly on various issues. And so various systems that do that have received a lot of attention recently. And one of those that I was hoping we would spend some time talking about on Thursday, when we consider what sort of issues there are in the Indian context to discuss, perhaps to make these kinds of things more manifest, is the extent to which jury systems or grand jury systems function in various communities as one very clear vehicle for community input or lay input into the justice system. So, so obviously you had a jury system for many years, and that was removed at some point, as has happened in many other countries and jurisdictions. But what we've seen in relation to the rise of deliberative democracy as an important outlet and vehicle for better state-individual and state-community relations and more procedural justice, just as we were describing, in relation to policing or to the relationship between citizens and other institutions. If you look at the relationship between the political structure or the justice structure, which is more of our focus, you'll see that many countries that had abandoned jury systems are now reintroducing them. And introducing them in very innovative ways that are different necessarily than the ways they functioned before. Or, you know, and similarly, countries that had abandoned a grand jury to try to vet criminal charges and decide who should be indicted or not, are also reconsidering whether they want to have that sort of process specifically within the criminal justice system. You know, so I'm hoping that we will hold this issue and hold this thought, you know, spurred by some of what's been going on here, for some more in-depth discussion about how deliberative democracy can really function. If you're interested in pursuing that in the justice institutions in India. So please give that some thought before Thursday, because we will come back to that theme, you know, which is way beyond family law, but encompasses really a variety of issues of justice, I think. So, you know, so that's the major answer that I would point to, because the notion is that lively dialogue helps to stop people from engaging in other kinds of protests because they have a voice. You know, so you're providing an outlet for that sort of discussion. Yes.
I just want to get back to what Professor Dhanda was saying. I think very specifically when you look at deliberative democracy, which is slightly different from legislation by the electorate themselves. On questions such as Brexit and on a vast set of questions where you have referenda, the point is very often on rights of people that you have to decide even though you're not going to be affected by it. So, for example, in this case, and for example in Ireland, where you have abolished heteronormative senses of marriage. You have relied on the vast majority of people to, you know, empathize with the LGBTQ community. Now, it's not necessary anymore, and I think that's what Professor Dhanda was pointing to at, is that now you can target people in very specific ways on the basis of how you identify culturally and economically. Now, that means that Brexit would be correlated to, for example, you getting your manufacturing jobs back, which is not really a fact. It doesn't have to be. You just need to target propaganda in a particular way. Now, the Irish people were lucky that that referendum went in their favor, but it's not possible that it would have the same impact. That, you know, you could fearmonger and target the right kind of demographics and have a desired result that's not exactly effective. Connecting this to a broader question of psychology, law and psychology, is that can you really legislate on rights on the basis of the fact that a majority recognize someone's right to marry or choose a partner, which is very different from when a legislator or a court is determining it, because there's still that framework of law that's your responsibility. Deliberation is slightly different in the sense that it's not that you're legislating yourself. I just wanted to make that.
No, thank you. And I think those are important issues to consider in the implementation and the uptake and the consequences that you're highlighting there in the differences. So, I think what we're pitting against certain issues there is the extent to which a sort of a populist view perhaps should have a role in determining governance and and how well informed it is. There are many issues associated with the quality of expressed opinions and debates as well.
In that case, I think even in psychology, this kind of haphazard sampling method or survey method is not considered to be a good research methodology.
You mean like a newspaper poll, or
taking sample or taking the survey opinion of the public?
Well, I mean, I think if you take like the Australian approach to use the Australian Bureau of Statistics globally across the country and community is definitely not a sampling issue. That's a population opinion. If they get all of the electoral voters, it's obviously going to exclude those people who are non-voting residents in the community, so that, that's a consideration. But yes, the sampling procedures used in any method of data collection are important. Are you getting a representative sample? What are the constraints on generalizing from a less than full population sample to the population? And so statistically, we are constrained methodologically from making those generalizations unless there are sound criteria that indicate that it's robust. So in some situations, you don't need to do a full population survey if you've got good sampling methods, but you need to demonstrate that. But yes, an unscientific sample, such as many newspapers or the news media engage in, with not necessarily well-crafted questions, not necessarily very well-fielded surveys, may produce very distorted views, and so you need to be cautious about the underpinning methodology when you're learning. Thank you. Yes?
Sorry, just one last.
Is the state using such data to influence mass psychology and obtain sense?
Mass psychology, I'm having trouble hearing the last word.
And obtain its objectives, whatever. Is the state engaging in this kind of plebiscites, this kind of data gathering, to manipulate, influence, and then finally achieve whatever it wants?
I think they were in such and it is an unusual procedure, but it's not so unusual that anyone is shocked by it, because it's seen, I guess, as taking the issue to the people. These kinds of things go on in the United States in general elections very frequently to try to get the electorate's views on a wide range of issues, and often what becomes regulated is the particular language that surrounds the presentation of the questions and issues on the voting forms, whether they're electronically administered or otherwise. So a lot of the argument over the extent of manipulation that you're suggesting might occur gets resolved by having special committees, that are charged with responsibility to ensure that the issues are presented in a neutral, non-biasing way. Of course, that doesn't affect what is necessarily said in other campaigns surrounding that, but that goes on in all presidential and other kinds of elections as well. But no, good point about the extent to which people can be manipulated. And
yeah, I suppose especially I think what all of us are saying somewhere, Jane, is that with the social media, as well as with this very targeted kind of messaging which has started to happen, and the fact that a lot of our preferences kind of get documented by these so-called data providers in a manner where we are not even aware of it. So you've started to have this, a lot of micro-messaging kind of things happening. Possibly this may be amongst the future issues that the psychology of law, or maybe more importantly, law and psychology need to look at more closely. I was just trying to make a connection between that kind of technological development and the fact that suddenly you have a lot of governments trying to popularize governance decisions by giving this appearance that we are consulting the people, when in fact, really speaking, I would say people are much more being duped. But I would go with you that possibly this is one of the things we can flag out and look more closely on Thursday and as issues for the future. The reason why I like, whether it's Brexit, a lot of people are saying Trump's election, a lot of people are saying our the parties come into power. A lot of this has got to do with this very particularized, very individualized messaging, which is coming to you in a manner depending upon your other broader preferences, which are getting documented all over the place, without us really even knowing about it. I think that's the, and if we are able to give it, dignify it as deliberative democracy, then it becomes even more difficult to question and challenge. I think that's the fear in different sorts of ways we are all expressing. But I am with you on the fact that it's larger than the family law question, which is what our issues of today. So if we flag it as one of the questions which may be in the whole realm of evidence-based legal studies we want to do, because after all, when they go for referendums, they go for plebiscites, they go for people's opinions. In your case also, they had to kind of root it through a specific legal procedure, and how that procedure is provided for or constructed becomes very important.
Sure. So let's reserve further delving into that issue, and particularly maybe the quality of facts and the quality of those kinds of campaigns and social media's role in that for Thursday. I think it's an excellent topic to look at and see how that bears on the whole. Okay, so just to wrap up some of these issues to do with same-sex issues and developments, similarly in Australia we don't really have unity on the question of the extent to which same-sex couples may or may not adopt. So, it's prohibited still in Queensland, Victoria, South Australia, and the Northern Territory, and permissible in other states, even though there have been challenges from our Human Rights Commission itself saying, look, this is a breach of international law, particularly Article 21 of the Convention on Rights of the Child. Psychologically, there's been a lot of investigation over many decades into this issue, and some of that work, sorry, I'm jumping around here, what happened? Meta-analyses again are quite persuasive because they draw together results of many studies. There have been no outcomes that were negative on children in general from all of that research. Then, as you will have read in the text chapter for today, where there were those interesting studies about Bobo, looking at how people develop their social identity and the extent to which role models might influence their gender roles or their gender identity. And I think it's really important to separate gender identity, and gender roles. And what some of that research showed, is that there was no danger if children were being well taken care of and had good, secure parental attachments. What's much more important is that positive well-being and the social and economic support for the child, and there's no adverse effect from having same-sex parents, adoptive or otherwise per se, so that tended to put an end to those kinds of issues. Yes, any comments or questions?
Well, we had, in our adoption rules, there was a point till which we, at least on a more strict scrutiny, permitted it. But we have now kind of, in our new adoption things, we are prohibiting people with same-sex orientation to adoption.
So why do you think there's been a turn back on that, or what's driving?
it's kind of strange that it's gone this way, because at one level you've got much more of acceptance for people with different sexual orientation. There's a more public presence. All of that has happened. Possibly, it's like politically we've taken a step back and we're calling for more conservative articulations, more traditional articulations, and because this is not a legislation, but the sort of rules that you have created around adoptions, that is causing for a slight back. And it's also in the whole realm of, one is adoption, one is taking recourse to what we call as artificial reproductive therapies. We are also not allowing access to that if you are not in a managed situation. So I
think the administration of it.
It's more to do with the fact that you're suddenly seeing some of these things as morality issues, and you're saying you're compromising on the kind of core morality with which in a society like ours should function, is maybe the prompting factor. I mean, just a guess.
I'll relate an anecdote. It's not a large body of data about a colleague of mine who decided to adopt after much consideration, probably if you look at gender roles in her marriage, she's very much the more assertive, driving, aggressive kind of partner than her spouse. And when they went through the adoption procedure, they realized that they were going to lose unless she completely changed the way she behaved in front of the adoptive scrutinizers. And so she said she had to learn, how to be somebody, offering her husband tea, sippering, and pretending to be very submissive and quiet, and deferring to him all of the time, because it was quite clear to her that if she appeared to violate these gender norms, they were very unlikely to be approved. So that sort of endorses some of those notions about, in practice, there might be traditional views about families that are militating when the decision making takes place. Fortunately, catching up. All right, so just a few items to come out of some of those materials on separation and reconciliation, and again, I guess what I wanted to highlight here is that psychological attachment theory, which I'll talk about mainly in relation to children, can also be helpful in looking at just family law between couples in a more broad way. And we had this odd phenomenon in 2014 where there were some programs that were implemented by the government, especially to help separating couples to reconsider. So they offered them subsidized family counseling, and that program was just another flop. Couples in those situations did not use or avail themselves of that opportunity, so that pretty much had to be abandoned. But a similar program implemented at the same time that really focused on reducing the trauma and the hostility between couples that are separating was more successful. And it is important to realize that oftentimes that hostility escalates and peaks somewhat before the period of separation and just after and during the separation. So if you're taking measures and you think that that's going to be predictive of the rest of their lives, you might get the wrong picture. It's a reactance to the stresses of the situation. But the kinds of things that psychologists have learned that it was predictive of negative outcomes of separation for the separating parties, and particularly the partners, not so much the children, in this regard, were poor communication. If people withdrew, sort of like the no longer talking example we talked about before, has very negative implications. manipulativeness, very distant communication or remote communication only through, not in person and only through other means or from far away, or just avoiding communication. Those seem to lead to worse adjustment or worse mental health for the parties afterwards. But I do want to turn especially now to issues surrounding domestic violence, where those kinds of conflicts and stressors, escalate as well, and talk about some of the issues in managing those that surround this question of separation of partners. So what we've learned across the world is that domestic violence or psychologically abusive situations, as well as physically abusive situations, are chronically underreported. Only much more recently have there been special shelters for men who are abused by their wives, and ways to encourage men to report because of the social opprobrium attached to being abused physically or psychologically by your wife. Very difficult for men to talk about that kind of trauma and that kind of experience. But clearly this happens in same-sex partnerships as well as normative heterosexual partnerships. It happens in both directions, and we need to be equipped to recognize it and deal with it either way. The problem that has been surprising to many law enforcement agencies is that people thought that if you just created shelters where an abused partner could go and get away from the abuse, or encourage them to finally leave an abusive relationship, things would stop. But in fact, they found that didn't put an end to the violence. So there's been a surge of interest in what sort of conditions and circumstances lead to the continuation of abuse and violence post-separation. And that's where some of the stalking research comes in. Stalking is a fairly new legal crime that has, new on most books in most countries, and is really, I think, grown out of psychology more than many other issues to do with criminal conduct have been the case. What we find is that, again, maladaptive responses to separation, particularly in individuals who have a kind of maladaptive attachment, are predictors of people trying to continue a relationship in the face of the other partner's desire to terminate it. And so if there has been some attachment disruption in the past, that can lead to specific kinds of stalking responses. And some of the underlying psychological explanations for why that happens are that when an attachment is severed, or what has been a secure, emotionally supportive relationship for perhaps a partner who's more insecurely attached, is that can diminish their sense of self-worth, threaten their self-identity, and that sense of insecurity can promote some dramatic and oftentimes violent responses. So psychologists for a number of decades have been doing research on different types of stalkers, and of course stalking is not confined to breakups of intimate relationships. There are stalking of movie stars, and fantasies about other people as well that have been studied. But some of the helpful work has been done by some Australian researchers. Paul Mullins, a psychiatrist who works in the forensic arena, and they distinguished 5 broad stalker types, of which 2, as I've indicated there with the asterisk, are most prone to commit violence following a separation that they're unwilling to accept. So we don't need to worry in terms of violence about the incompetent kind of suitors who just go on pursuing somebody following them because they're well aware that somebody's uninterested in that, but they are adaptively making the wrong decision. They don't turn violent. Those who are, somewhat more morbidly infatuated, who might experience some anger and rage, don't necessarily turn violent, but if they did have what we would describe as a narcissistic personality disorder, then that rage might be more of a motivator in that direction. But those who are really resentful tend simply to want to frighten the victims through their stalking. And when I say stalking, it doesn't have to be physical. It can be stalking by sending 50 or 100 text messages a day, abusing other kinds of social media to sort of intrude into somebody's world and their presence, as well as following them physically or going to places where they're likely to turn up. So stalking is very broadly defined. The ones to worry about are those who are really driven by revenge, who might be especially enraged if the person who's broken up with them now has an interest in a new partner, and that can be more than they want to tolerate, and that motivation can lead to violence. But also those who are predatory in their nature, who really enjoy the power that they get from stalking and engage in fantasies often about sexually assaulting the victim. So that's more of a sexual adaptation. So that's somewhat helpful, but how are people who are responding to a complaint about domestic violence or threats that are being received? How are police supposed to figure out how to take certain issues seriously or distinguish between types of stalkers is a very difficult task. And so the major mechanism that has been used legally to protect people is in our community and in the United States, well, in Australia, are called apprehended violence orders, where you go to a court and you provide certain facts and you say, I need protection, this person is not allowed to approach me, has to stay so far away from me, not allowed to contact me any longer by telephone or social media or whatever, in the hope, excuse me, that will deter them. And what we have found is that despite the presence of these orders, what then happens is there's a whole lot of litigation that ensues over violation of those orders, where people who've had them in place, and our police in our community can actually initiate the orders if they go to a scene of domestic violence and the parties haven't initiated themselves, so police can become the initiators and get those orders in place. But then our police spend, a very intensive amount of time responding to alleged breaches of those orders. So in 2014, they counted 13,000 responses alone to breaches of AVOs that were in place. And so you can see this has been generating a huge amount of work for the police, and yet doesn't seem necessarily to solve the problem. And people who've looked into this in more depth have realized that there are many causes for the difficulties that police experience, sometimes since that they don't really understand the law that well themselves. If you go carefully back through some of those slides that I provided on complaints against the police, there are quite a few that are just on responses to domestic violence. And in some situations, we found that police thought that they couldn't do anything unless somebody actually had been physically assaulted and struck. And that if there were reports of abuse without any evidence of bruises or bashing, that they could do nothing. And in fact, that's not what the law provides. And so that was a barrier to effective policing in these situations, because it seemed to require the risk to have escalated to quite an extreme degree before there might be an intervention. And sometimes, they were confused as to who the initiator and the responder was, because sometimes they're mutual orders of restraint. One party gets an ABO, so in retaliation the other party goes out and gets an ABO, and the police are confronted, by all of these papers, and they can't tell any longer, who's really the one to worry about who's just doing this, as a quid pro quo. So it's become quite a messy area of enforcement. The public, when I did a survey of representatives of parties in domestic violence situations, because we had an advocacy unit that's attached to our legal aid offices, where people who work exclusively with this kind of case provided feedback on what the problems were that their clients reported. We found that a large proportion of them were concerned that the police in these cases failed to take the calls from parties who were under severe threat and sincere threat. They failed to take them seriously enough, and or they were unprofessional in their responses. And so they weren't, so there were poor actions as well as inactions, and those were about equal in the complaint group that we analyzed. And these were also sometimes complicated by judgments being made that were unfriendly to the parties seeking help. So we had quotes about police calling both sides baboons, and telling them they were behaving like animals, and they, and hoping that was going to stop the problem, but in fact it did not, or otherwise being, very dismissive, sometimes blaming victims, sometimes trying to coerce people into behaving better. Those were not effective responses. So what has psychology been able to do looking at this arena? And one thing that I wanted to share with you are some interventions that have been developed specifically for police. So this checklist was designed by two psychologists. Sheridan's in the UK, and Paul Roberts is in Australia, and now at the Western Sydney University, and he has done a lot of work with police over the years. And what they were trying to do is find a series of fairly straightforward and simple questions that police encountering these situations could go through that were known to be discriminators between cases that were serious, where the threat was real and imminent, and cases that were not. And so they devised and tested out this set of 11 questions that just require yes/no answers. And so police can keep this checklist, be trained on it, and when they encounter those situations, ask the parties these questions, and then if they get affirmative responses, then they know that this is an escalated situation, it's serious, and action needs to be taken. Not necessarily by them, but this needs to be escalated in their responses as the situation needs better monitoring or better intervention. So that's how that works.
Does it help? Was it tried? Has it helped?
Yes, that's been implemented in the UK, and I think also more recently in Australia. There are some publications on it that they have published, and as far as I understand, the police have found that helpful. And what is especially interesting about this list is it actually, in many ways, matches a similar checklist that was developed independently by different forensic psychologists in Australia that we reported in the chapter called the SPR system, which is used in conjunction with a much larger multi-team integrated response where there's a triaging process set up through an interdisciplinary unit that monitors these kinds of cases and also is making distinctions between those that are very serious and those that aren't, so that attention and resources can be directed to the more serious ones.
I sort of am asking this question because amongst the very constant problems that we have, especially in relation to what are seen as gender-related crimes, or that you find a report of domestic violence, stalking possibly, it's a very recent introduction into our penal code. It is coming as recently as 2013. So one can't really say how its implementation is working out. But for domestic violence, all right, there has been this very constant thing where the police tends to be dismissive of, like you say, it's a family matter, you should sort of start to sort it out, and hence where is it that intervention is necessarily and urgently required, and where it's just a spillover, which possibly, if see the kind of report which comes from their side is that just as we start to gear up, things kind of get sorted out, and then you feel it's much better that you didn't take it on board at all. And the kind of complaint which comes to the very purpose of having such a legislation gets defeated if the police start to play counselors rather than to enforce the law, which is their duty. So I was wondering whether an objective kind of a checklist like this is helpful in terms of getting the implementers to decide where is it that they must really move in, and where, if supposing all of these items are answered more in the negative than the positive, that may be a case where they would go a little slow and decide later.
Exactly. Then it wouldn't indicate that the risk is high. Yes. So its purpose is to provide you with an indicator in a simple way of risk, so that can then be assessed more thoroughly, precisely for that. And I think what we learned from some of our work with the policing community is that part of the resistance, was that police often regarded domestic issues as not core crime issues. It didn't, they were sometimes reluctant to be assigned to teams that worked on domestic violence because they didn't see that as real crime prevention or engaging with real crime in the same way. So there were some attitudinal and organizational issues associated with it. And actually, if you look at the statistics, you will see that the extent to which domestic calls constitute police work is clearly a major part of what our police are being sent to address. And so it's very core and has required quite a bit more education to overcome those kinds of attitudinal barriers. But other kinds of interesting developments in this area, and I don't know whether you have these here in India, are different technologies to try to get around some of these issues of people violating the ABOs. And so some major work has been done recently with GPS-type devices, both for the victims as well as for the perpetrators that are quite interesting. But let's have your question or comment.
It's not about a question. It's not a question, ma'am. It's regarding to the Tara Madam's information. In India, in Indian context, the domestic violence is being kept under protection officer. That's a legislature. It's an enactment in 2012 which came up, and it has been given under to the bureaucrats rather than to a police department, home department. So in case, so it is very sensitive issue. A woman who approaches to the police station, her marital relationship is on a context of very dilemma situation. So they have kept it under the protection officer so that police interventions are not taken, and it is being counseled initially. And later, in case the things are not working out, she has some remedies to approach court and get a certain reliefs. As you were mentioning, AP orders, we have protection orders. Rather such, it's an umbrella type of an act in which we have a number of reliefs. So the woman can approach to a bureaucrat, and she can inform that I'm undergoing such of this domestic abuse, and can I get so and so reliefs. So this is one of the contexts. And coming to the stalking, I work with women, so I have often came up with the reports of the husband being stalking them or troubling them. In that situation, do police be informed that see, this woman is being harassed, and kindly call the husband and tell that he shouldn't do such any abuse to her until that matter has been settled properly. So the stalking in Indian context has been taken in two terms, ma'am. One is outside outside the relationship of domestic relationship and inside. So outside is like a college girl who has been going outside, who is going out and he has been stabbed by some other person, been followed. So in those cases, police file a case under 354D, which is a recent amendment ma'am as she was telling. So that has been taken care by a special branch of police department called as GIAN. So in in Hyderabad especially, this initiative idea of cheating has came, which take care of the women who are in the open space and being protected. That's what I wanted to share.
Thank you, that's really interesting.
I wasn't sort of making that clear kind of, I think the point which is being made by Archana is primarily she's making this distinction between the Domestic Violence Act, which is kind of, we could say, I mean, there are different ways in which it is described. Some people describe it as a civil legislation, some as a quasi-criminal legislation, and the sort of various interventions which operate from there. We have a parallel provision within our criminal law also, which is to address the whole criminal offence of cruelty and largely within the family. And it started out with like a very rigorous kind of an implementation of that provision, to a point where the apex court of the country itself is saying that there are a lot of very false or if not false, then very frivolous and quick complaints which are coming under there, and they want an entire filter system to be put in place before any kind of FIR is registered or any other investigation prosecution happens. I was making my comments virtually collapsing the two kind of thing, because even when it comes to Domestic Violence Act and the seeking of protection or the sort of assistance and intervention, we find a similar kind of prejudice plays out. See? So I was using policing in a more generic sort of way, whereas you kind of are making this distinction between the police as properly so called, and other people who are given policing responsibilities. I find that both activities happen in a very gender stereotypical way, where you are asking largely that the woman should adjust, so to say, and we should really, really worry about whether there's in fact that kind of a need for intervention. And the gender stereotype gets reinforced or re-articulated at several levels. At the policing level, at the adjudication level, and at even at the legislative level sometimes. So it's I think I was responding, and just as a clarification, I was responding from there to say that maybe if we sort of started to create more objective kind of checklists which allow for intervention to happen, where intervention must happen, instead of subsequently, when a person dies or commits suicide or a whole huge tragedy happens, then everybody wakes up and says, oh yeah, she was saying this or that to me. But short of that, you're expecting a lot of people to just lump it. It's something very synonymous to the point I was making that day when I was talking in terms of workplace hostility, talking in terms of creating these very misogynistic kinds of responses to issues, where you don't really worry about the fact that this is no way to treat anybody. It's like if the fact that nobody is talking to her, the apex court of the country says it's not cruelty. It's like only if she's been really slapped around and beaten black and blue, then it is cruelty. Anything less than that doesn't really count for. And what does it speak of in terms of, the entire humanizing of public and private spaces? Is the sort of question for me is a constant worry. And I feel if psychology can assist in that process, the point which you said, that it's ostracism and what it does to people, you're being excommunicated or you're not being talked to, or a sort of peer pressure is being built on you that you behave in a certain kind of manner, or we have nothing to do with you. I was just sort of joining those dots.
Sure, and I think that the research showing that there is no difference in the rates and types of domestic abuse, whether you look at male on male in same-sex couples or heterosexual, or women on women. It's not a gendered issue per se, and so to take it out of a gendered context is quite important.
I just wanted to add on one piece of information which a lot of people find hugely problematic. Our Domestic Violence Act only addresses violence against the woman. So if the victim is a man, the statute has no kind of remedy, which I per se find problematic. But the rationale behind, I can explain, is that the rationale is that it's believed that the moment you make it gender neutral, it gets hijacked the other way. And you suddenly find a range of women getting lined up for, though ostensibly the legislation came to protect. And it's kind of in other contexts it has played out. We've had, in the realm of marriage, and because we're doing family, in the realm of marriage, we had this entire business of that you could not dissolve a marriage. Till the reform in the marriage law came, there was no provision for dissolution of marriage in Hindu law, which is and the entire set of representations which were made amongst the grounds on which dissolution of marriage should be permitted was the ground of insanity. And the constant kind of representation made before the Reform Committee was, you permit it because otherwise you have these helpless women being saddled with quote-unquote insane husbands. As a result of those, any number of petitions which went before the Reform Committee, the provision came into the law. And when one found subsequently, when you examined who was using that provision, it was primarily women getting divorced on the ground of insanity. The insane husbands, one found, figured in the defensive insanity cases where the largest single victim within the family was the wife. So it's it's like, I'm understanding, explaining why it came that way, but consequently, because it came in that manner, when the victim of the domestic violence is not a woman, but maybe a more vulnerable man, you do not have a remedy within the law.
So we've identified in the course of our discussions across the last several days quite a few areas where issues about gender-specific legislation have loomed into prominence, and I guess what you're highlighting here too is the importance of how those are used when the uptake of the law itself is another whole issue to address. So I would say those are topics I would hope we would come back to in our wrap-up on Thursday as well. So trying to create more sort of effective victim-centered methods is what some of this technology has been aimed at, and this kind of approach has been very well endorsed by police where it's been trialed, which has so far the most comprehensive evaluations have been done in the state of Illinois in the United States, and more recently in Australia. And the Australians much more favoured a personal alarm system that the victim could wear because that was clearly within their control. There was more ambiguity, they felt, and more confusion about the effectiveness of a GPS device attached to the perpetrator, and especially the police endorsed the notion, I think 2/3 of them in a survey, that you have to understand that the GPS is not itself a protected device. It's not going to save someone's life. It simply gives you more real-time information about whether somebody is actually breaching an order to approach within a certain territory, and gives you more expansive ways to define what those territories are, where often the paper orders, just talk about a distance but don't really allow zones of exclusion and inclusion. So those were liked. And I think what was really interesting about the US implementation is that it was also cost effective, and they shifted, most of them were in effect for about 100 days, and they shifted the cost to the perpetrator who had to pick up those fees, and that itself was seen as an attendant enforcement mechanism that was absent from some of those other mechanisms. So quite an interesting set of things to look at. The 2016 Australian Victorian Royal Commission on Domestic Violence has a large-scale report assessing many empirical methods of enforcement and trying to look at these issues. Sorry?
In tangent with drug and urine screening.
In tangent with drug and urine screening. Yes, the US model has said that because somebody might provide the device to somebody else if they're really devious and trying to work around it, you might still need to do other monitoring of the perpetrator to see whether they're complying with all of the terms of the order, and that for long-term deterrence about violence, you might need to do some drug or urine screening, or even alcohol screening, because alcohol is often a precipitator, if those are terms of an order to try to minimize the issues. And so the notion here is that you can't rely just on a GPS. You need to look at a larger suite of measures to really fully redress these concerns. There are some other topics that I want to turn to, but I think that this one here, just to wrap up this area of discussion, is quite important legally, and that is the question of, when there are those cases such as you were alluding to, where things, get to the point that somebody is stalked, and murdered by an intimate partner who's made repeated threats, or even be jailed for making threats and then released from prison. As we described in that one case in our textbook, I think the Patterson case. Who's responsible, and is there any recourse to individuals who have contacted the police numerous times, had orders enforced, but nonetheless still being vulnerable to persons that are acknowledged to be risky? And what you find is that sometimes these cases, when someone has lost their life and the family's very grieved, have come up under the notion of breach of a duty of care, either a duty of care, to keep people safe or to investigate efficiently and promptly. There's somewhat, minor differences in the way that is framed. And there have been vastly different responses in different countries as to whether or not police should be held liable for that kind of duty of care and breaches. So that Australia and the UK, for example, have been unwilling to impose that on police. Canada has taken a different tack, and there is a recognized tort now of negligent investigation, which would encompass those kinds of cases in particular. And so I've just summarized there some of the policy arguments that have been made in light of this trend of litigation to give the police immunity from accountability in these kinds of circumstances. And so those are summarized there. And I guess, I'm asking you implicitly to consider what the circumstances are here and what might be supportable in your community. So there are a variety of arguments, but very clearly, I think the more contemporary approach is to shift some of the responsiveness in these situations away from police only, and to have more integrated interagency response teams to go through that screening to plan other kinds of interventions. So we describe quite a few of those in our text on what is the emerging new response to those. So that would indicate that that goes in tangent with the idea that there should be less accountability just of police to deal with these complex situations. All right, so end of that series of topics, and I want to sort of finish up with much more that's focused just on marital dissolutions, and particularly ways to deal with the end of those disputes, and custody arrangements often loom into prominence in those disputes. And one of the guiding principles there is the standard of best interests of the child. So you've probably heard that phrase if you've taken any courses on family law, or if you've taken any courses on child care and protection. And I think that what is really interesting about it is that, you know, it doesn't have any explicit content. And so where is the content going to come from? And to sort of highlight the fact that it's really, you know, a principle, you know, with changing content, we summarize some of the ways that the content of that doctrine has changed, and how what it means has been differently interpreted over the years. So that initially, you know, the tender years doctrine presumption was applied, which was that for children under 7 years of age, you know, custody should always go to the mother, was, you know, but it was a rebuttable presumption, but that was the thrust of the assumption. So clearly an assumption in the law that has now been psychologically challenged. There were formal challenges in the United States under the anti-discrimination law provisions that it was harsh on fathers, was in fact, again, you know, if you're looking at a gender-neutral standard, it was discriminatory. Nowadays, the models have shifted so that when there is a separation, there is a shared obligation of legal custody in many communities, so that both parents have legal decision-making rights. But the important issue to understand is that while there might be equal decision-making rights, that's very different than who actually is the major timeshare caregiver. So you can have, you know, equal rights as parents, but in fact the child might be placed with one parent primarily and have intermittent visitation rights with the other. It's not that the child spends one day with one parent and the next day with the other parent. And those kinds of arrangements, while they sometimes are implemented, are quite difficult on the parties, and people have worried even more that they might, you know, in order to create this fairness between parents, put an insuperable burden on children to keep moving around, you know, from one home to the other. And where do they keep their school books, and where do they put their study, and so on. You know, if you're in order to create this equity, really disrupting the child's life, that's not going to be in their best interests at the end of the day either. So the issue of finding a timeshare arrangement that is in the best interests of the child has become a major psychological focus. And that led to the content of the terms best interest becoming filled with notions about who is the primary caregiver then, or the psychological parent, which again brought that attachment theory more into sharper focus. When we did a survey in Australia of what people thought best interests meant, we discovered that there were, you know, many different conceptualizations among people working in the field who are experts legally or experts psychologically on this term. But what seemed to come out of our empirical research in a large-scale survey was that the safety and protection from harm should be the first priority in implementing this principle, and after that, the health and well-being of the child. So take care of those very fundamental needs first, you know, then look at other priorities in a more graded fashion. Yes, ma'am, you're covering next.
Thank you. I just wanted to ask, does the culture of a particular nation make it easier, or the culture of a society make it easier for a child to digest the idea of time sharing? I'm asking this because when I met a few foreigners, and the person said to me that I spend the weekends with my mom and I spend the weekdays with my dad, and so of my life to different people. And I don't want to share what I did on the weekday with my mom and what I did on the weekend with my dad. But this concept was very alien to me. But it was as easy, it was just as easy as it was like packing a bag on Friday night and then going to his mom's. So I was assuming that because divorces happen more in the US and this is more frequent in the US, it was easier for him. And since I'm from India, we still, at least it's not that frequent. It's probably alien to me. So am I correct?
I think that the extent to which that kind of frequency of change works and is comfortable for the child depends on the degree of cooperation between the parents. So part of what you have to look at is whether you have couples that are what we call high conflict or low conflict at the time of separation, and the extent to which they are really willing to put their own selfish interests in the background in resolving these issues and place the interests of the child in the foreground. And when the separated couples can do that, then that shifts a lot of the distress away from the child and makes the adaptation much more straightforward. So yes, you do have couples who separate and end up, continuing to live very close to each other for the convenience of the child, so that the child can, in fact, readily, just move from one environment to the other. They both keep, full sets of clothes, or figure out some easy way to make that exchange because they have an ongoing cooperative communication between them. But the high conflict couples are going to use those exchanges as ways to engage in more aggression towards the ex-partner, and not focus on the child. And so, you might find, that if you pack a bag with the child's clothes, it'll just never come back from one parent if they're not in a cooperative mode, and that parent might just be hoarding all of the possessions, or so it very much depends on the family dynamics. And so a lot of the thrust in this area has been to try to promote more cooperation between the parties and not have them focus on any of the issues that might be residual between the parents in resolving what happens to the children.
I'm sorry, my focus was on asking whether the culture has any effect on a child being more used to the time sharing.
You mean just in general? I don't think we've looked at the culture per se. I think children are very adaptable, and obviously how things work in a particular cultural situation might minimize or maximize conflict for them. So, and also I think there's so many more children these days who are coming from families that are reconfigured in some way or another, that makes it easier for them to adapt. So if they're in a community, where they're not the only child, that they know who's got parents who separated, who's engaging in this kind of new living arrangement, that alone gives them, more solidarity with others, So children very quickly figure out when they go into a class, how many other children in the class are in separated or reconfigured family arrangements because they have a sense of alliance and allegiance and solidarity with those other kids. And so that can help them with adaptation. So in the sense that that's a cultural factor in a community, that may make a great difference. All right, so one of the issues in most legal systems is the extent to which you should consult children about their wishes when you're making decisions about where they should primarily reside, and that's where child development psychology can play a role. Yes.
In that case, what about the attachment theories, age-old attachment theories that are coming up?
Say again.
Regard to the conflict of the childhood experiences that will reflect in the adulthood later. All these things, what is to be done? Just like a few years.
I mean, it can be an issue that needs to be individualized. You know, you can't just look at chronological age of a child and say, you know, this child should be consulted because they're, you know, 8 years of age or 14 years of age or whatever the norm might be in a particular jurisdiction. For doing that, you need to look at the individual circumstances. But there has been much more of an emphasis in the last several years that children's voices and children's rights need more consideration, and that these matters are not simply affecting the parents, and that there ought to be some way for the input of the child to be taken. And if you're worried that they're going to be manipulated by, you know, a Disney-type parent who's just been, you know, plying them with gifts in order to get a favorable response, because then the child's going to be asked pretty soon which parent they want to spend more time with, or major time with, or any time with, you know, then you need to have very careful ways that you can engage in the consultation to remove or take into account those potential kinds of biases. So it needs to be done artfully, and also needs to be voluntary. Not all children should be pressured to make an opinion. Some might feel that the pressure of expressing any preference is a sense of disloyalty to one of the parents if they feel, you know, attachment to both parents. And so you don't want to force children into that situation either. And of course, this is an area where experts are often used to provide advice to courts, and that's where some of the issue about parental attachment or parental alienation looms into prominence in these cases. And I think what we've learned from attachment theory is that it's really largely independent of biology. You can have attachment with a caregiver who's a non-family member or an adoptive parent that is significant. And what we've learned in addition is that really, you know, what's very important in a child's life, and this comes out of a lot of extensive developmental psychology work, is what goes on in those first few years before about the age of 33 months. So if you don't have a very stable, warm, you know, clear, healthy attachment that takes place in that time frame, oftentimes years later is when we're seeing the consequences in things such as personality disorders that emerge and other maladaptations to all kinds of separations. So if that's not stable, then separation between partners can be something that precipitates some of those maladaptive sort of stalking responses that I was talking about. So attachment theory is quite significant there between the parties as well as the children. And I did want to highlight the important cross-cultural tests of attachment that have been applied both to infants as well as to older children that we documented in that section of the chapter, you know, particularly the strange situation test or the use of Q-sort cards, a different methodology, and the importance of not misinterpreting infants' behaviors in those situations. Right, so, and the last really important point to highlight about attachment is the discussion about parental alienation. I don't know if that is a term that has emerged at all in any of the cases here or the jurisprudence here, but it did have a lot of popularity in cases in other countries, particularly it seems stimulated by lawyers, you know, working as advocates on behalf of their clients in high hostile kinds of cases, where as the litigation increases, so the hostility increases, and then one parent alleges that the other is turning the child against that parent in various ways, so that an ongoing relationship is disrupted by negative aspersions about that parent, which, you know, go on and include sometimes fictitious claims of child sexual abuse. So that itself has become an issue that psychologists have looked at closely. And the term parental alienation syndrome has no empirical basis. There is no set of behaviors or or such that constitute any diagnosable syndrome of that sort. What is true, is that it is socially inappropriate and damaging to denigrate one parent in this kind of conflict situation, irrespective of whether there's any diagnosis attached to that. So part of what we're limiting here is the database and the way that can sound more clinical or psychologically damaging than there actually are data to support. But otherwise, it's a more of a commonsensical thing. So to look at those high conflict situations and try to reduce it, I think the most far-reaching reform in Australia is the one I want to finish up talking about, and that is the mandatory use of mediation. Since 2006, so it's had about 10 years of operation now, in family law cases, either separation or custody. And important points to highlight here are that the legislation requires that they engage in a sincere or genuine effort to try to resolve matters informally with the assistance of a mediator who is appointed. And there's a whole program that has been started to ensure that those mediators are well trained and accredited and registered. And there are different places that you can engage with mediators to implement these kinds of sessions. And in general, what they found, is that this cuts out a lot of the acrimony and the adversarial effects on the family, because what you're trying to do is build a set of consensus and agreement that will last into the future. The litigation will end, usually if you defer to someone's judgment, but you still have to go on dealing with these family members long into the future. And this appears to be a more productive way of producing stable decisions that last, so that people don't return to the court at all. You can return to mediation if you need to fine-tune a contract that is reached, but at least 2 out of 5 cases settled, and in part that's the major barrier seemed to be a misconception about what equal legal custody means. In other words, many people go into the mediation thinking that that means equal time, and there's a huge difference between equal sharing of the decisions, as I highlighted, and who gets the major primary caregiving responsibilities and timeshare on a day-to-day basis. So until that misconception is removed, the success rate, I don't think, is going to be quite as high as it might otherwise. But I think by this preliminary evaluation, people have already identified some of those barriers and are now systematically addressing those, so that I think this system will, be more and more successful. There are cases that have to be exceptions, and those are cases where there is really high conflict, family violence, and the history of child sexual abuse. Mediation is not a particularly good forum to resolve those, particularly because there's an imbalance oftentimes between the parties, or you need more professional assistance and specialized knowledge to deal with them. So, right at the end of our time, what I want to say is I think that we have covered in this area of content quite a lot of examples that show how the law has led to different reactions from humans, particularly perhaps the abuses of ABOs and all of the litigation generated by ABOs. Also the example of the parental alienation syndrome that moved into cases that went through litigation. But there are also many examples from the family law area of psychology in the law and of the law. So it's quite an important educational area to explore in really understanding the relationship that psychology and law can have. Any further discussion or comments that people would like to make as we move towards closure? We've highlighted quite a few things, I think, for Thursday. Is mediation used routinely here in the same sort of way that this ADR program has been implemented in Australia?
We do have provision for, there's some level of mandatory counseling which is required in, and there is provision as such for, I'm not fully aware of as to how systematically it is used. There's much greater stress on counseling rather than mediation, and generally people feel that it is that counseling is a hurdle that they have to overcome before they can have a dissolution of their marriages and whatever. Mediation is more, I think, coming from accepting the fact of dissolution and then to say that, okay, the after effects of this should be handled in a non-acrimonious manner. I think we haven't put as much attention there as to the fact of, trying to the very end that the marriage stays and you can get the couple back together. Which
that sounds a bit more like the Irish model, where
which isn't particularly, it's the general kind of response or feedback you get from various people who occasionally there will be a success, people may sort out things and stuff, but largely what people tend to say and what counselors also tend to say is this, that you feel like infantilized. You feel that, as if to say, I don't know my mind and the court knows it better or the counselor can handle it better for me. That's one kind of response that is...
that seems quite similar to the failure in Australia of the uptake of the counselling that was offered. That wasn't where people wanted the attention.
Mediation is, I at least understand it differently. It's more to sort of look at the fact that if the marriage has not worked out, how do you handle those, the subsequent consequences in a manner which are non-acrimonious. And I think possibly that could be more productive, but I'm not aware of it being systematically used.
Right. Some of its real strengths seem to be that it does empower the parties to forge solutions that might never be available through the law. And if people who know their circumstances intimately in a way that a judge or some other neutral party is never going to know them, you have a chance to work collaboratively to really forge a solution that works for you. So if you know that one partner is going to move away, you can deal with that, whereas dealing with that legally is quite cumbersome and awkward. But you have the option to be very creative as well as to kind of customize all of the issues that you're familiar with, working through someone who's trained to help you identify those issues and come to agreement that then oftentimes gets lodged with the court. And there were even some hybrids that were tried. So we talked in our chapter about this other sort of I think we called it sort of less adversarial trial. So if you try mediation and the parties just, can't reach agreement, and you want an evaluative output, from a third party, you can go through what now is called a less adversarial trial, where all of the information that might be disclosed in the mediation is in front of that fact finder, who simply helps to craft the order that you can't reach without the high conflict and the negative fallout from the adversarial relationship where the parties are facing competition. So it's a much more cooperative and collaborative kind of trial. So in order to get around the negative effects of going through the trial route, quite a few different new models have been emerging.
In Indian
I just wanted to say that we have another event immediately after.
I'm not printing that much time.
No, carry on.
In Indian context, the mediation mostly is being used in case of mutual divorces. What I have practically seen in my field of work, when husband and wife want not to go much of litigation, so they go for the mediation and they get an agreement and go for mutual divorce. And in terms of mediation.
So it's a great cost saver instead of retaining lawyers, so you can have lawyers in mediation or not.
I have been in one or two mediation centers, and I was not allowed to sit inside. It was a mediator and the parties.
Right, because they're often confidential, and the idea of the confidentiality is to promote full disclosure so that you can say things that you can never say in court.
But what I have observed is like after the session, there will be given a number of sessions, 1 or 2, 3, and they have been driven back. They come back and they take consultation from us and they take advice from us and do I have this for the certain terms or not, and then it is been again driven by the lawyers only. That's what I have been observed.
No, thank you for having us in. Right, so we need to draw this to a close. Thank you very much, and see you this time on Monday.